according to section 219 of the Indian Contract Act, an agent is entitled for his remuneration, agent to be indemnified against any contacts, against any of the consequences of lawful act. Good morning and welcome to the session 7 in Unit 3 Commercial Law, where we are going to talk about the rights of an agent. Now, the rights of an agent is quite different and quite interesting to know. Let's start with the first one. The rights of the agent are as follows. The first one, right to receive remuneration. What is this remuneration all about? According to section 219 of the Indian Contract Act, an agent is entitled for his remuneration. Definitely yes. Why? Because even if I am going to work as an LIC agent, or I am going to work as a sales agent, or I am going to work as an automobile agent, I would expect some payment for my services. So that is what we call here as the remuneration factors altogether. Now, the section 220 says that an agent who is guilty of misconduct in business of the agency is not entitled for any remuneration of the business which he has conducted. Now, the main thing about doing an agency work is that you maintain the loyalty and sincerity to the business. Many a times it so happens that being an agent, we tend to overpromise, we tend to take things into our confidence and start doing the work, which is not an accepted manner. Why? Because there are times, there are chances that you might do something which is unwanted in nature. You might do something which is illegal to the business. You might tend to promise, collect money on your own, and that might lead to the problem altogether. So in that kind of condition, section 220 says, suppose an agent has been found doing some mistakes, doing some kind of misconduct, which actually leads to the disgrace of the business unit, and he has been found doing it guilty altogether, then he will not get any kind of payment for his services. Because though out of the 100 businesses that he might have got, one he might have done wrong, but if he is proved wrong for that one, the remaining 99 would also be considered as a misconduct altogether, and this would lead to the non-payment of his services. Moving further, now the right of lion. What is the right of lion as per section 221? Agent's lion on the principal property. Now, how does this come into picture? In the absence of any contract to the contrary, suppose there is no contract, agent is entitled to retain the goods, papers, and other property, whether movable or immovable, of the principal received by him until the amount due to himself from the commission, disbursements, and services respect to the same has been paid or accounted to him. Now let's look at the general factor here. In the absence of a contract, to the contrary, that is, normally for any agency, any kind of activity, business activity, there needs to be a contract. Suppose we don't have a contract, so that is why I say to the contrary, that is opposite to the contract. When there is no contract, the agent is entitled to hold back the property, the documents, movable or immovable assets that have been told by the principal factor of the principal. Why? Because if the principal has not paid him the money that is required altogether. So this is where it becomes very, very important for all of us to study and to understand. He says very clearly here that whether it is a movable or immovable, the principal that is being received by him until, see, for example, whatever money the principal has to pay, the principal has to give him as a part of the service. Suppose he has not given it, then automatically it becomes a very, very important factor that the agent can retain the things for himself and not give it back. Why? Until he receives that payment. So this is only possible in terms when the contract is not there. It is just a belief. It's a right over his line altogether. Followed by right to indemnity, which says agent to be indemnified against any contacts, against any of the consequences of lawful acts, which means to say promise make good loss, which means to say the contract of identity. When you see that, according to the section 222 of Indian Contract Act 1872, it says that employer of the agent is bound to indemnify him against the consequences of lawful acts of all such agent in exercise of authority conferred from him. So in case of all the factors where the promise to make good the loss, suppose in case if there is going to be any loss made by the agent, then the employer, the principal, has the rights to recover all the loss from the agent. Why this is again important for us to study and to learn at this juncture is that many a times when you want to take up a sales job, you might feel that it is all about selling and earning the commission. But let's understand, from the business standpoint, you become liable for each and every act that is being done by you there. So, which means to say that sometimes it is possible, it might be seen altogether, that if an agent by chance, by mistake, did not know about it, he just took it for his confidence, he just took it for his limitation, his factor, and he started selling it. At the end of the day, he understands that he has made a loss for his employer. Now, it's very, very common when we are talking about an agent, sales agent kind of role in some sophisticated goods, in some luxury goods, in some high-end products. Suppose you did not apply your due diligence and you made a mistake altogether for the person, for the company, then it is bound that you might get into a severe loss, into a severe condition altogether, where you have to repay it back to the employer, to your principal altogether. Followed by the illustrations. B at Singapore was a person actually under the instructions from A of Calcutta, contracts with C to deliver certain goods to him. A does not send the goods to B and C sues B for the breach of contract. Look at it. B at Singapore is a principal under the instruction. He's an agent at Singapore under the instructions from A from Calcutta. Contracts with C to deliver, but then A does not send the goods to B, which means the principal did not send the good to the agent. So now what happens is that because of the breach of contract, C will sue B saying that you didn't send the goods. Now that's against the contract. I will put a case against you. B informs A of the suit and A authorities him to defend on the suit. B defends the suit and is compelled to pay the damages and cost incur expenses. A is liable for B for such damages, cost and expenses. Now what happens is that this is a pure case where you see that the A, being a person, a principal, did not send the required goods. So he did not honor the contract. Now who got involved into it? B, the agent, got involved in this case, and he has to face the liability on the side because the person C, that is the third party who's going to buy, he said that since you didn't honor the case, I'm putting a legal case against you. Now what happens? Agent informs his principal that I am going to face a legal case. So the principal gives the authority to his agent saying that go ahead and defend this case by yourself and you take care of the expenses by yourself. So upon the case undergoing, he has to take all the liabilities and expenses occurred, and at the end of the day, the principal now becomes liable to the agent to pay back all the expenses. That is what we need to understand. Suppose the principal does any mistake, suppose the principal leads to the loss to the agent, then the agent will have the rights to recover his money from the principal itself. This is very, very important for all of us to learn here. Followed by which, B is a broker at Calcutta. So B automatically is an agent here. By the orders of A, a merchant there, contracts with C for the purchase of 10 casks of oil from A. Now, afterwards, A refuses to receive the oil and C sues B. B informs A, who repudiates the contract altogether. B defends but unsuccessfully has to pay and manage the cost. A is liable to repay back all the costs. Now, if you see a small twist in the case, B is a broker who went on the behalf of his principal A to a third party C, saying that he wanted to purchase 10 caskets of oil for his principal A. But at the end of the day, A refuted the entire contract, saying that I'm not at all interested in buying. Now what happens? The third party is not going to keep quiet. C will come back and put a case on B, saying that it's because of you. You had promised me that your principal will buy, but now he is not buying. So you have to face the case. So now what does the agent do? He goes back and informs his principal, saying that, sir, I am being now legally tangled in this case. I am now legally involved in this case. What should I do? But here, A does not even recognize the entire thing. B has to go through the case circumstances. At the end of the day, what is very important is that the principal A has to pay back to the agent. Now, principal has to recover back all the losses to the agent at any point of time. So, it is very, very important to understand this concept that the agent can go back and recover the losses from the principal. Now, the second thing is right to compensation. According to section 225 of the Act said, agent is entitled to claim compensation for the injuries suffered as a consequence or want of skill of the principal. Now, this is very important. Why? Because section 225 reads, principal must follow the compensation of his agent in respect to the injury caused to such agent by the principal's neglect, want of skill, which means to say, any kind of injuries that is being caused to the agent as a consequence or want of skill. Now, what happens here is that, let's take a normal case. I want a person who's going to work as a stunt master or as a person who's going to involved in some loading exercise, some agent. Now, what happens is that during the course of work, that agent occurs some injury. His hand breaks, his leg breaks, or he undergoes some accident. Now, it is the duty of the principal to go ahead and compensate for that injury. That's what we say, right to compensation. Principal has to pay back all the losses, all the damages caused by that injury. Followed by an illustration here. A employs B as a bricklayer in a building house. Now, bricklayer is not an easy job. It involves a lot of manual tasks. You need to handle the goods. You need to be careful about the way how you take up the load, and puts up the scaffolding himself. The scaffolding is unskillfully put up and B in consequence gets hurt. Then A must pay the compensation to B. What happens is that they have not taken a proper measure. Automatically, the person B who gets injured because of the non-proper alignment of the system, of the situation. So now it becomes the responsibility of the principal to go ahead and compensate to the worker. This is what we say, principal to the agent, the right of the agent to recover his compensation. With this, I come to the end of this session. I hope and believe that all the information shared through this session will be of a great value and resource to you. In the upcoming sessions, we shall try to learn more about the different facts of commercial law. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.